Okay, I think it's been a minute or so and there's got quite a lot of people that are in now. So I will introduce myself. I'm Laura Cooper. I am a co-head of the Youth Justice Legal Centre, which I run together with Katia Moran at the Youth Justice Legal Centre, which is part of Just for Kids Law. Thank you all so much for coming. We're really pleased to have you today. And this is actually the 9th guide in our series that we've been producing together with the Children's Rights Group at Doughty Street Chambers. And as many of you will know, if you've been to some of the previous launches, these legal guides are sort of part of what we do at YJLC in terms of helping others better advance children's rights in the criminal justice system. So each of these guides that we've been launching are on a key youth justice topic, and they're all intended to be really practical tools to help fight for better outcomes for children. So today's guide, Richard, if you could show a picture of it, is on court, bail and remand. And as many of you will know, over recent years, there's up to one in 3 children have been in custody on remand, with last year's figures, which I think Richard Bridge, one of our speakers, will correct me, was up to 45% of children are in custody on remand. So, you know, given this figure and the trauma and pain that we know prison can cause to children, this is rightly attracted to scrutiny. And so the overall number of children, although the overall number of children in custody has fallen significantly, there's still a lot of issues around remand, you know, including things like lack of viable alternatives to custody and more scope for meaningful action to improve practice. So on the back of that, we have produced this guide, which is an overview of the law on bail and court bail and remand, and it also examines the corresponding duties of the local authority and provides, importantly, practical tips on what can be done by practitioners within the current system to prevent the pre-conviction detention of children. So quickly before we get going, I just want to say a massive thank you to Shawneen Lamb, Susan Wright and Amos Wohlmann for their amazing contributions in writing and putting the guide together. And then also just a reminder to everyone that if you have any questions, please do put them into the chat Q&A function, please, and address it to whoever of the speakers that you want to have the question addressed to. And also if you're tweeting about the event, the hashtag is Youth Justice Guides. So to tell you more about this issue, we brought together a panel of leading experts who've got a massive amount of experience and expertise in this issue. So I'll go straight on to our first speaker, who is Richard Bridge. He is Head of Research at the Youth Justice Board for England and Wales, and he has recently published research on remand, and he's also responsible for overseeing the YJB's annual statistics, and he's able to provide us with, you know, really unique insight into these stats and the data. So I'll hand you straight over to Richard now. Thanks, Richard.
Thank you, Laura. Welcome to everybody this evening. And we just go on to the first slide. So I'm going to speak primarily today about a piece of research that we actually commissioned and did. It was published in February 2021. So this particular presentation is really around disproportionality, ethnic disproportionality in remand and sentencing, but I'm going to speak primarily about remand. So go to the next slide, please. Yeah, so the key findings that we came up with on that particular
Hi, Richard. Sorry, having a bit of trouble hearing you.
Was possibly.
There we are.
Can you hear me now? Is that better?
Yeah, it sort of it was going a bit slow, but it's even here now. So let's go.
I'll tell you what. I'll drop my video, and then if it, maybe. I don't know whether that will help or not, but it should be. I'm in a government department, so it should be fairly stable, but I don't know why. So what I was really trying to say is that ethnic minority children, unsurprisingly, did receive more restrictive remand options and harsher, longer sentences than white children. Now, there were some explanations for some of that disproportionality, which I'll move on to in a moment. And similarly, that can relate around demography, but it can also relate around practitioner assessed risk and also the well-being of children. So there are some explanations, but nevertheless, the disproportionality primarily for Black children could not be explained by any of those objective factors and so forth. Now, Laura mentioned about the data and the stats in terms of remand data, and it's very, very stark in terms of the differentials in terms of the number of children who are actually remanded from Black, and if you compare against their counterparts who are white children. So we can go to the next slide, please. So we also found a couple of interesting points here. So again, perhaps depressingly, not surprisingly, we found that practitioner assessments suggest that Black and at risk and also more vulnerable. Piece of research around bail package reports, and something that we can actually really look into, particularly around potential language, adultification, and understanding why that may be the case, why those assessments do assess in those ways. I've spoken about the second point, but the main one is relating to this Black and mixed ethnicity children are, once you control for all of these factors, we know that Black children are less likely to receive community remand by 8 percentage points, which is pretty stark when we look at it. We can go on to the next slide, please. So I'm going to try and go through this relatively quickly. So this slide and the next slide after this do speak about these different objective factors. So we might look at sort of the difference in average age. We might look at the differences in gender by ethnicity. We know that there's a bigger proportion of girls who are white than their Black counterparts. And we also interestingly find that there's more white children who are likely to be locally resident to their youth offending team than Black children. So if we can go to the next slide as well, please. And I spoke previously around the differences in practitioner assessed risk and well-being. And again, these are sort of interesting findings in terms of how that may further explain disproportionality. And there's something around here which we call the assessed likelihood when we compare that to the actual likelihood, and we find that there's a differential of 37 percentage points for Black children. And that reduces, there's still a differential there for white children, but that reduces down to 20 percentage points for white children, and there's mixed and Asian in between. If we can just move on to the next slide, please. So also then I want to just talk a little bit about some really interesting qualitative research that sits alongside our research that was done by Yannick van der Brink just prior to the pandemic, where he spent quite a long time in a couple of different magistrates' courts observing quite a number of different youth remand hearings. And again, there's a really interesting aspect here around, there's a real sort of focus on risk and need, welfare need, this sort of vulnerability aspect of it. But also really interestingly, something that we would like to pick up on our next piece of research is the linkage between the judiciary and practitioners within courts. There's a huge time constraint that we actually observe in that, and therefore the courts are under pressure. And probably this is exacerbated. We don't have the research to support this, but with the backlog in due to COVID, I suspect that time constraint has probably intensified as well. And I think there's something here that he's recommending, whether sufficient attention is given to the assessment of evidence in that first hearing, and whether that threshold should be raised. So we can go on to the next slide, please. There's a couple of interesting quotes here, and they speak of the adultification of Black children particularly, again, in terms of how vulnerability is often perceived or considered. And, you know, I won't read each and every one of you, but, you know, big and tall and Black makes it easier to make decisions about not being vulnerable, which he actually was. I think there's the importance of language and potentially conflation of Black boys are always in gangs rather than, and that seems to be suggested in this particular case. That's a potential issue with the judiciary. And so again, that might be something that we can pick out with our future research that we're looking at. And then that point around swift justice, which is like the most important thing, is let's make a decision as quickly as we possibly can do. And the real difficulties and challenges that are faced by youth justice services in actually providing relevant and useful information so that remand decisions can be made, based on the as much information as is possible. And then the final quote in the right hand corner, I thought was also hugely interesting. And again, this does talk to the judiciary sort of recognising the real importance of youth justice service practitioners in saying, look, this is what we've got available, this is what we can do. And probably it also speaks to the importance of relationships that are developed or not developed between youth justice services and the judiciary and courts and so forth. So yeah, that's the main crux of my presentation. Now, if I can just go on to the last 2 or 3 slides, I'll just skim over them and people may want to take a look. So I have put something there around our future research around the quality, efficacy and use of pre-sentence reports and also bail package reports. And we're also looking at some interesting research, separate piece of research around ethnic disproportionality in reoffending outcomes, totally separate to this. We can go to the next slide. And I'm not going to sort of dwell on this particular piece, but I have put some remaining questions in there. They're open questions, but I think they are questions that need to further research or that need to sort of look to actually answer that. Now, our particular piece of work that I've been speaking about was quantitative work. So I think these questions probably need primarily to be explained wherever we can do through some of the qualitative work that we may be undertaking or others may be undertaking in the future. So thank you. I hope I've not gone over time, but yes, thank you very much for listening.
No, that was perfect. Thank you, Richard. That was great. Thank you very much for that. So our next speaker is Amos Wohlmann. He is a barrister at Doughty Street Chambers, who has a human rights-based practice which incorporates crime, regulatory, court of protection and inquests. And he specialises in the representation of young and vulnerable clients, and has previously been recommended by the London Legal 500 Directory for his representation of them. So over to Amos to provide us with the legal framework around remand. Thank you, Amos.
Thank you very much. Good afternoon. I'll just take you through. There are a lot of slides and the legal framework is quite large, so I may skim over them, but obviously it's all set out in the guide and the slides, which should be available for you to consider later. There are a few but significant differences in applying for bail for a child as opposed to an adult. There is useful guidance in the Youth Court Bench book and there's a flow chart for decision making in appendices 1 and 2 of the Youth Court Bench Book. Detention considerations for children are set out in sections 98 to 102 of LASPO. Next slide, please, Richard. The starting point, section 4, as in adults, there is a presumption of bail, except in certain circumstances prescribed by section 25.2 of the Criminal Justice and Public Order Act. And those include for people who've been charged or convicted of certain specified offences, for example, murder, attempted murder, manslaughter and rape. So they've previously been convicted of those offences or a culpable homicide. And if it's a child or young person, if the previous conviction is one of manslaughter or culpable homicide, and the child or young person was sentenced to long-term detention under any of the relevant enactments. Next slide, please. The same objections apply to children as adults, set out in Schedule 1, Paragraph 2 of the Bail Act, namely a failure to surrender, commission of offence whilst on bail, or interference with witnesses, or otherwise obstructing the course of justice. Next slide, please, Richard. An additional objection specific to children set out in section 5 of the Bail Act is that the defendant need not be granted bail if the court is satisfied the defendant should be kept in custody for his own protection, or if he's a child or young person for his own welfare. And that case has been subject to legal challenge, which was resolved relatively recently, although the case itself took place some 9 years before, but it was resolved following the conclusion of another authority. Essentially, a declaration was sought by the applicant of incompatibility under Section 4 of the Human Rights Act to the effect that own protection in as far as it relates to a child or young person is not compatible with Article 5 of the Human Rights Act of the European Convention on Human Rights. In that case, the High Court held that provided it was for a short period of time, it was in exceptional circumstances relevant to the nature of the offence itself, and only if there was no reasonably available other means to afford protection in those circumstances, there was no violation of Article 5. And so although in that case it related to police bail, the same principle was discussed in terms of court bail. Next slide, please. There are a number of grounds on which bail can be withheld, and they're set out on the slides. Child is already in custody serving a sentence. There is insufficient information to make a bail decision. The child's been on bail in these proceedings and is arrested for breach of bail conditions, and it's impracticable to complete inquiries or make a report unless the child is in custody. Next slide, please. So the first condition is, the first consideration is it should be unconditional bail. The court may impose conditions on an adult or young defendant's bail for the defendant's own protection, or additionally for a child or young person's welfare or in their own interests. If the court's concerned that unconditional bail can't be granted, the court must consider conditional bail, and appropriate conditions can be devised by the youth offending team or youth justice service, who can offer bail support and supervision to help allay any bail concerns. And they'll need to assess the child and their circumstances to present a suitable package to the court. Where the court doesn't consider standard bail support and supervision to be sufficient, and as an alternative to secure remand, the court will consider conditional bail with intensive support and supervision, or ISS. Next slide, please. There is a possibility of a curfew. A curfew doesn't need to be electronically monitored, although it usually is. Doorstep curfews are still implemented. But in order for a child to receive credit for any time subject to the curfew, it must be electronically monitored, again, as in the case for an adult, for at least 9 hours a day. And each day spent on curfew results in a deduction of half a day from any subsequent custodial sentence. Curfews can only be imposed in the circumstances set out paragraphs 7 and 8 of the Youth Court Bench Book. Next slide, please. In fact, the next two slides just set out those paragraphs 7 and 8, which should be there for you to consider. So I'll move on swiftly given the time constraints. Just moving on then to conditional bail with ISS. You can see, and again, it's set out in the guide. It's not a creature created by statute. It's an intensive community-based program for young offenders that can be accessed via existing disposals. The local youth offending team will indicate whether the offender is suitable for ISS, but ultimately it's a matter for the court to decide whether bail is granted and whether ISS conditions should be attached. Conditions may include tagging and voice verification. Where standard bail support and supervision isn't considered sufficient and is an alternative to secure remand. So it should only be proposed and used as a last resort. Next slide, please. So remand to local authority accommodation. If the court satisfied there are reasons to withhold bail, the child or young person is remanded to local authority accommodation with or without conditions, unless the strict criteria in section 91.3 of LASPO for remand to youth detention accommodation applies. And that's contained in paragraphs 11 and 19 of the Youth Court Bench Book. The court must always consult with the local authority by the youth offending team before imposing any conditions on the remand. Where the court does withhold bail, it must state in open court the designated local authority that's to receive the youth. This will be the local authority where the youth habitually resides or where the offence was committed. And the local authority must then provide or arrange for accommodation for that child or young person. Remand to local authority accommodation can include living at home with parents, even though bail has been refused, if the local authority assess this to be the best accommodation option. And the courts can stipulate that the child must not reside with a certain named person. Next slide, please. Remand to youth detention accommodation is only lawful if bail has been refused and certain conditions have been met. There are two ways in which a child can be detained, set out in sections 98 and 99 of LASPO. Again, just moving on quickly, there are two sets of conditions, either of which must be satisfied before a youth can be remanded to youth detention accommodation. The first of conditions is effectively based on the seriousness of the offence and need to protect the public or prevent the commission of further offences. The second set of conditions is for other imprisonable offences and can only remand if there's a real prospect of a custodial sentence. Next slide, please. So again, not going to read the sections out, but as I mentioned, the criteria set out in sections 98 and 99 of the LASPO. So if we can move on to the next slide, please. And again, in relation to real prospect of custody, paragraph 35 of the Youth Court Bench Book confirms that when considering the sentencing condition and the real prospect of custody, the Youth Court Bench Book should consult the overarching principles sentencing children and young people. And in fact, if there are no child-specific guidelines, it's appropriate to refer to the adult sentencing guidelines. The Bench Book continues that the court must be very mindful that the minimum custodial sentence in the youth court is a detention and training order of 4 months. So if there's no real prospect of such a sentence, then a remand to youth detention accommodation is not permitted. Next slide, please. Sorry. Refusal of bail, any further applications. If the court's refused bail, it's the court's duty at every hearing to consider whether the youth ought to be granted bail. Where a youth has been remanded into custody, they may make a second application to the subsequent court and put forward any argument, even those previously argued. If that application is refused, the next court need not hear arguments if it's been previously heard. If there's been a change of circumstances, however, the youth has a right to make further applications. and it has been held that the passage of time itself may be considered to be a change of circumstances in particular cases. And there is a duty to have regard to the child's welfare as a reason to allow repeat bail applications, in the case of Brent Youth Court there being assistance in that regard, as is section 44 of the Children and Young Persons Act, requiring the court to have regard to the welfare of the child or young person. Next slide, please. The jurisdiction of the Crown Court, if a child's denied bail by the Youth Court or Adult Magistrates Court, or wishes to vary bail conditions, the child can apply to the Crown Court to reconsider an application for bail. And the prosecutor also can appeal in certain circumstances to the Crown Court against the grant of bail if the child is charged with an offence punishable by imprisonment. Next slide, please. Breach of bail, I'm sure it's something familiar with, not a separate criminal offence, but the police can arrest a child if the police have reasonable grounds to believe a breach of bail has taken place, must be within 24 hours, and the court must determine whether the breach took place. The court must release the child on the same conditions as before, unless of the opinion the child is likely to fail to surrender to custody or is breached or is likely to breach bail. Next slide, please. The court's powers following breach, the court can bail again on the same conditions, add conditions. The child must be, or the child to be remanded to local authority accommodation or remand to youth detention if sections 98 or 99 of LASPO are met. When a child breaches conditions relating to the support package with the youth offending team, it's a matter for the youth offending team whether to bring the matter back to court. Next slide, please. In fact, there is no next slide. Apologies. That concludes my section. I hope I've not run over time as well.
No, that's great. Thank you very much, Amos. That was a really good overview of the legal framework. So now we have, moving on to Sean Gray. Sean is a senior practitioner at Lambeth Youth Justice Service, and he manages a caseload of young people, as well as having responsibilities, including training and development of the Youth Justice Service staff and court and diversion work in the Youth Justice Service. And he regularly attends Bromley Youth Court as a yacht worker, as well as the Crown Court. And this involves completing risk assessments and supporting bail support packages for children. So handing over to Sean for the Youth Justice Service perspective. Thank you very much, Sean.
Thanks, Amos. So my presentation is on some of the practical yacht and youth justice role, and also some of the focus on how to possibly obtain slightly successful bail. So I should start by saying I may use different terms kind of interspersed, including yacht, which is youth offending team, youth justice service, and similarly with children and young people. But I'll start by just saying that yachts, we are an implicit part of the youth justice system, and that includes within the domain as well. So our views are sought by the court in relation to aspects of children's welfare, risk assessment, and that leads into aspects of bail and remand of young people. So when we talk about bail and remand of young people, I just want to highlight some aspect of a distinction between young people who are produced from custody on the day in comparison to young people we are previously aware of on the court list. In the sense that essentially, there's in my experience anyway, there's usually a lot less information known around young people who are produced at court from the cells on the day of court. The reason for that is because if we're aware of a young person who are already on the list, we would have completed our kind of checks and operations before. So we should already have a lot of information known around that young person, whether they're currently known to the yacht team who are in court on the day, whether they're known to a different youth offending team. We would have made that contact, ascertained all of that information you see in the third bullet point there, as to whether they have previously been known to a youth offending team, what the nature of that involvement was, the level of risk they were assessed as presenting or posing currently, previously, any safeguarding concerns as well. So all of that essentially will go together, and that will kind of form the picture which we're starting to build up of the young person in terms of risk assessment for court on the day. Liaison with a solicitor is an absolute imperative part of that, which ideally would have been taken place beforehand, but in reality and circumstances beyond our control sometimes, that's just not possible. And essentially we would look at obtaining the CPS views on bail as well. That is a key aspect, because we need to be able to respond to any objections the CPS put forward into why they are either advocating for remand of a young person or supporting bail. So the last aspect of that, in terms of what we use to kind of formulate risk assessment of a young person, is what's already in existence from any previous involvement with youth offending teams, previous convictions, what's in the CPS documents in relation to the offences they're appearing for. But it's information held by other services, children's social care. If a child is open to children's social care, the nature of their involvement, be on a child in need plan, child protection plan, looked after child, and they will have usually a lot of information, which will be absolutely imperative really in terms of relaying to the court for the legal advocate to represent the young person in the best possible way they can. The PERS record, the person escort record, PERS in short, so that refers to essentially the document which is which it records all the young person's movements and presentation, any suicidal or health concerns from the point they're in police custody all the way through transport and to the point they're in cells at the custody suite in the court. So as the yacht officer, I will go down to the cells for a young person who's held overnight, check that record to see if there's anything of concern, and just identify any notes which have been made by the police or by the court detention staff. So I'll relay that to the solicitor if that is of concern, or a youth offending team if they're not currently known to youth offending team I work for, and relay that if it would help them the solicitor or the home represent the young person. Next slide, please. So I won't cover this in too much detail because I think Amos helpfully covered it in quite a lot of detail around the theory and the legal aspects around this. But yeah, just to kind of reiterate that young people in the youth court, there is a presumption that they will be granted bail, as stated in the Bail Act. But where the CPS have particular objections to bail, the yacht have a duty in order to submit a bail package to the court, which will address any of the specific concerns. That may be around the likelihood of absconding, the likelihood of further offending, any non-compliance on previous instances of bail previously granted as well. So those bail conditions at the top, that's just some of the most common bail conditions which I've seen kind of attached to periods of conditional bail, residency, exclusions from areas and so on. That's not an exhaustive list. You can be quite creative, I would say, in what you can recommend. It has to be balanced in line with a young person's circumstances and also the concerns raised by the CPS. Bail ISS, as Amos has already covered in his previous presentation, that is essentially used as a direct alternative to a remand in youth detention. So it is quite onerous and it does have a number of components. The key aspects of those are an education component, which is usually supposed to be 15 hours of structured activity during the week, usually 25 hours in total that the yacht would have to recommend for the young person to be engaged in over the period of a week. And there's an electronic curfew aspect as well, which is imperative part of Bail ISS. Some of the kind of main factors and certain aspects which we would be considering in relation to whether to, or the court will be considering as to whether to grant bail or otherwise, are kind of detailed in the third bullet point there, which I've stated. So essentially compliance on previous bail, any previous yacht orders which they've been subject to, engagement, what work was actually completed, the nature of any previous convictions, and if the matter they're appearing for, on this court appearance, if there's a pattern of similar related offending or otherwise. Also considering the young person's vulnerability, some of those aspects I've just included there in terms of speech language communication needs, and an EHCP, Education Healthcare Plan. that is an imperative document to ascertain whether a young person does have an EHCP, because that outlines a number of aspects in which a young person may have difficulties. It could be behavioural, it could be cognitive, it could be language, and so on. And essentially, the local authority have different obligations to put funding in place in order to ensure a young person is supported best as to whatever the identified need is within the EHCP. Some of the difficulties which we encounter a lot are around the availability of accommodation and the suitability of accommodation. So that is something I'll kind of go on to a little bit in a second, but it's that's where social care have a number of different responsibilities, and we have to liaise quite closely with our counterparts in social care in order to ensure that any package put forward is really robust and it's available to the court. But I would say the wording of any conditions, of any bail conditions, is very important, because we need to balance the kind of risk, needs of the young person, any positive activities they may be engaged in, alongside some of the objections which the CPS may have for bail. So, for example, quite a common one I would say is rather than just identifying a named address for a young person to reside at, you can kind of make that more loose in essence, and say that a young person should be directed to reside by the local authority, reside as directed by the local authority. So if that address does need to change at any period during the bail period for any reason, then there wouldn't be a requirement in order to go back to the court to have that varied. Saves a lot of time, essentially, in practice. And just a little note in terms of remands, that last bullet point there. It's not a decision made by the court as to where a young person will be placed in a custodial environment, should they be remanded and bail refused. That is a matter which is decided by the Youth Custody Service Placements team. And they take a number of things into account when they decide where a young person is to be remanded. If it is remanded into youth detention accommodation, bearing in mind that strict test as well. And they will base their decision largely on the recommendation of the youth offending team. Whether the young person is previously known, that be based on prior information and prior risk assessments, combined with the assessment which is made by the court officers on the day of court as well. And yeah, if there are concerns as to where a young person may go, into which establishment, that is something which the youth offending team and the youth custody service can hopefully address together. Next slide, please. So I just want to touch on some of the work which actually Lambeth Youth Justice Service, who I currently work with, are doing at the moment to hopefully reduce the number of remands that young people we have. One aspect we're doing is kind of combining, or kind of really increasing our relationship we have with our local foster carers. The overall aim of that is being to increase the number of foster carers we have who are willing to act as remand foster carers, which will hopefully prevent a young person having to stay within the police station overnight to be produced for court the next morning. If a young person is arrested and is taken to the police station, there is a process in place where the police contact social care, if it's during normal hours, or the emergency duty team, and they will seek background information in relation to a young person from the social care system, and also from our youth justice service system that are currently open as well, which will help them decide and essentially support the rationale for granting police bail to a young person or otherwise. We also have CAMS, Child and Adolescent Mental Health Services, Liaison and Diversion Practitioners, who are based in 2 custody suites. And they complete a screening with each young person who is in police custody, just to identify any concerns in relation to their mental, emotional well-being, and then they will relay that to the police or key professionals involved in the young person's care, and hopefully provide some support as well. We've set up legal coffee mornings, which have been going now for over 6 months. That's kind of led by myself and practitioner, with legal representatives who we are aware regularly attend police custody or local youth courts, essentially. Purpose being to share best practice, share any concerns which we identify in relation to conduct or language used or negative outcomes and so on, any updates in relation to the legal world, practice changes and so on. And we invite specialist speakers to the meetings as well. We recently had our police team and our speech and language therapists who have an excellent presentation in relation to identifying the needs of young people and how to best communicate with them in what are very difficult environments, a small room, in a police station, in a court. We've completed refresh training to our court staff who cover duty, and we've taken the position that where we have a young person who may be at risk of remand, we always put forward some form of a bail package to the court, just for that the court are the ones that make the decision as to whether a young person is granted that bail or otherwise. That is simply better than not putting forward any kind of combination of a bail support package. And I'll just say the importance of the youth justice practitioner being present at court cannot be undervalued. Particularly, I'll say this in the Crown Court, because I think the Crown Courts, they're not as well rehearsed in terms of managing young people, dealing with young people who may be appearing for what are very serious offences in the Crown Court. We don't have the similar recording systems. We have access to different databases. So I think it is really imperative that the youth justice practitioner from a yacht is present in the Crown Court, should they know that a young person is going to be. Next slide, please, Richard. And just some final kind of practical advice and I'll call take homes. Ensure, if you're a solicitor on this webinar, speak to the yacht officers on duty at the court. I cannot emphasize that enough. And if you don't do that, I think that is not best practice. Similarly, if they know you are the solicitor, the yacht would usually come and approach you as well. I kind of reiterate that really on my second there. It's not just between solicitors and between the yacht. There's a lot of other people, a lot of individuals involved here to get the best outcome for a young person. But it's the solicitor, the defending team, social workers, parent carers, any other relevant adult. We all hold so much information and so much different information, but it's useless all just holding on to that. We need to share that information in order to conduct what is a holistic assessment of the young person. That will minimize the likelihood of any potential unknowns coming up on the day of court itself, and for legal representatives to be able to advocate more strongly for the young day of court appearance. Sounds straightforward. Speak with the child. I don't mean a kind of 5-minute consultation and just check that, that they know roughly what they're doing or what they're going to plead and so on. It's actually really understanding the process and explaining the process to the young person. Maybe their first appearance at the court, it's very daunting. Do they know who is in the court? Do they know why there's 3 people there as opposed to 1? Magistrate and a district judge, for example, who sits where in the courtroom? Is there an appropriate adult, etc., etc.? Take time to do that. Preparation, key aspect. The more you know, the more prepared you are, the more likely, in my opinion, you're likely to get a successful outcome in terms of bail for a young person. And should a young person not be granted bail for whatever reason, continue the liaison between solicitor and defending team. Youth offending team contact details, they're on the website, they're available nationally. If you know which youth offending team are responsible, hopefully you will do at the end of the court appearance. Make contact if you don't already know them from the conclusion of court appearance, because at any point, as Amos highlighted previously, you can apply for bail for a young person, and the court should consider that anytime a young person comes before the court again. That is it.
Thank you, Sean. That was really helpful. That was great. Thank you very much. So we've got our final speaker is Ikea Stevenson. She is legal director at Just for Kids Law, and she has specialised in youth justice work throughout her career. She leads the criminal defence team at Just for Kids Law, which she co-founded 14 years ago, and she represents children at every stage of the criminal justice system, from the police station right up to the Supreme Court. Prior to her legal career, she was actually a bail support officer at Westminster Youth Justice Service, and also through her role at Just for Kids Law as legal director, she has knowledge and expertise regarding the local authority duties and their relevance to criminal practitioners. So really happy to hand over to her for her insight into how lawyers should best approach trying to get bail for their young clients. Thanks so much. Thanks, Ikea.
Thank you, Laura. So at this point, I'll just let you know there are no slides. This is really just my bit to bring it back to sort of practical points for practitioners, which is what I do best. So I think the first point I need to make, obviously, bail applications are the bread and butter work of any criminal defence solicitor, and they are the thing that solicitors do most frequently and often best. However, in relation to children, I think it's really important. We know there are much less children in the system, and there are many practitioners that don't represent children as frequently as some of us that specialise in that work. So really, most importantly, you should refresh your memory of the test. The legal test is actually quite hard. It often won't result in a remand if it's actually applied properly. And there are many applications for remand that actually are resolved by simply approaching the prosecutor and the legal advisor before the case is even heard in court, and actually going through the test with them and saying, you know, are we in agreement as to whether this actually meets the criteria? I think having those conversations, there are many cases that I have dealt with that have looked like a remand initially, but actually when you go through the test don't meet it. And that's, you know, obviously the best position to be in is to not be having to deal with the CPS opposing bail. And the second point I'd like to make is really that it's the role of the solicitor to create the narrative vulnerability in relation to children and young people. Richard referred to adultification of Black children in court, and we know that Black children are most likely to be remanded in custody. So this is simply Black children are seen as less vulnerable, more resilient, more mature, physically stronger. Therefore, how that translates in someone's mind is more likely to survive in custody. And we as practitioners need to create that narrative. The last person likely to describe themselves as vulnerable is actually the young person themselves. So they are unlikely to give you that information. You may get it by having much wider conversations about different issues around their education, who they live with at home, their mental health, whether they needed extra help in school, that will assist you to create that narrative, but they're never going to describe themselves as vulnerable. So it's really important to speak to as many other people that have contact with that young person and see what their view is as to their vulnerability and how they would actually cope if they were remanded. So as Sean and Richard have referred to, when the youth offending team are on board with providing a bail package, essentially they are your best friend when it comes to your bail application. And that is all great when they are on board, but the issues really for practitioners are when they are not. So I think it's important to think about how you can challenge the assessment of risk. Most often, the reason why a youth offending team won't provide a bail package is because they are concerned about the level of risk of that young person committing a serious offence or coming to serious harm themselves, and the local authority then finding themselves in a serious case review. And that's difficult to overcome, but it's important that practitioners think about, well, how have these decisions been made? How have we got to the point of a young person being assessed as so high risk that there isn't an alternative package that can be put forward? So there are concerns that Asset Plus itself, the tool that is used by youth offending teams to assess risk, may result in Black children being assessed as higher risk. So it's important that you check that they have all of the up-to-date information about that young person, particularly if they're not currently on an order or not previously known to them. And we are open and able to challenge that assessment of risk. If you get to the point where the youth offending team are still pretty adamant that they are not going to provide a package, then you can engage community care solicitors who will actually take on the issue with the local authority to actually challenge the decision not to provide an address and not to provide support, particularly if that child is a looked after child. But once the child is in custody for a period of time, then they essentially will become looked after in any event. Finally, create the bail package yourself. If you are in the situation where you have no options, then you can do it anyway. There are stringent conditions that you can offer, and there may be community groups that a young person is accessing that would be more than happy to be part of that package. I think it's important that you pre-warn those community groups that that if they are actually part of a bail condition, that they will then have a responsibility to inform the court if a child doesn't attend their provision. So it's important that you do that, but you can put that forward to the court as things that a young person is doing voluntarily. So it's really important to look outside of the youth offending team and see what other things that young person would like to engage in and how they spend their time. And we all know that 74% of the children who are remanded do not receive a custodial sentence. So it's really important, as Amos said, to bring the court back to the last resort guidance that's set out in the sentencing provision. So whilst you're dealing with pre-sentence, you must draw the court's attention back to that, because whilst they may be thinking of, well, a remand, it's a short, sharp shock at this stage, we know in most cases that doesn't work. Now, I started my career as an advocate for the Children's Society, and that was my role then, was to advocate for young people who had just arrived in custody, having been remanded overnight. And those young people were extremely vulnerable, and the process of them becoming hardened happened very quickly in custody, so within 2 or 3 days. That is essentially why I started my career 20 years ago. I see the same happening now. And so I think that it's really important that we're not complacent about bail, despite the reduction in children in the system. And that's it from me.
That was great. Thank you so much, Ikea. There was some really helpful tips there, I think, for practitioners. So should we get straight on to questions? We have a number of questions. So I think we'll start with the first question for either Richard or Sean. And the question was, do you know if the PERS record, I think that's how you pronounced it, is a national document, and can you tell us what it stands for?
Are you happy to come in on that one, Sean? I think you'll be better placed.
Yeah, I believe it is a national record. I'm not 100% sure, but I know it does stand for the person escort record. It's usually shortened to PERS, essentially. Yeah, it's completed by detention officers in police custody, and then goes with, in this case, a young person from the period of transport from the police station through to the cells at court.
I think somebody else has answered that in the chat as well and said, yes, it is. So next question is for either Amos, Ikea or Richard. Apparently some youth justice agencies take a local decision to not formulate a bail package for offences like murder, attempted murder. How does the panel consider this, given the statistics your research has identified? So I don't know who to start with first. I don't know whether, Richard, you want to start or Ikea?
I think from my perspective, it would be interesting to hear where the local authorities, their position first on actually providing packages in that situation.
Might be better for, I think you'll have a better experience of the local context.
Sorry, we didn't really quite hear you there. I hope that sort of answered the question. The
Just to sort of add to that, I would say that I'm currently working with Lambeth Youth Offending Team and local authority who have been more than accommodating in preparing a package for a young person who is remanded in custody on a murder charge. It's not to say that we will be successful, but they've certainly been on board in assisting us in getting something together that is is considered, what could even be considered by the court. So it's not impossible, is all I would say.
Great. So a next question again for Ikea. It's quite a long one, Ikea, so I'll go through it now. So it's a question from the Anti-Trafficking and Labour Exploitation Unit. The question is about potential victims of trafficking on remand with a positive reasonable grounds decision, and they almost never have a suitable bail address. But if they are a child, they're entitled to this by the local authority. So in an immigration bail context, it says in an immigration bail context, it's possible to apply for bail in principle where a person has a positive reasonable grounds decision. And so an immigration bail judge grants bail in principle with an order that the Home Office finds suitable safe house accommodation within 7 days. And criminal solicitors have told the charity that it's not possible to apply for bail in principle in the same way in the criminal courts. Is that right? And did that make sense, Ikea?
Yeah, no, yeah, that sadly that they're absolutely right. There isn't a specific exception in criminal.
Right.
So long question, but short answer.
Okay, great. Okay, next one is for anyone who wants to answer it is, does someone from Yacht always attend the Crown Court hearings? And what can a lawyer do to try and get a Yacht staff member to the Crown Court for a bail application and to get a social worker to attend if they have one? So I don't know whether
Want me to come in on this one?
yes, please. Yes, please, Sean.
I mean, I think, as I said in my presentation, I think in all cases where a young person is having parents in the Crown, there should be some representative there. If it's not the first appearance, however, then like I say, I think sometimes there may be miscommunication, because we don't always become aware of the outcome of the previous hearing. If a young person's in the Crown Court or when the next date is. So it is really imperative, I think, that you have that relationship already with the solicitor or the attending counsel and the Yacht. But I'd say if you need us to get there and you know when date it is, which court it is, obviously, then make the phone call. The phone numbers of each Yacht are contained on the government website. And similarly with social care, we would know who the social worker is, so that will usually come via the Yacht, so we can ensure that social work will be available as well.
Okay, does anyone else want to come in on that, or is that sort of answer that one? The next question is sort of another short one, and for you, Amos, is a Crown Court bail application different to a youth court bail application?
Oh, that's a good question. It depends on the judge, really. I mean, it shouldn't be in terms of youth. It shouldn't be, but the different judges have different sort of practices and also different knowledge about youth procedures. So I think, if you can find out about the judge and what their sort of their view is first, that's usually a good starting point. But it should really, obviously address the same statutory criteria and the same procedure. So it should be the same.
Thank you. So a question next for Richard. Somebody has asked, in your view, should those making biased sentencing decisions get training in regards to BAME children? Sentencing decisions, I think that's correct. What has been done to reduce or stop these prejudices?
Can you just repeat that again, Laura? I didn't quite catch that.
Hold on a moment. So it says here, Can you hear me? It says, in your view, should those making bias, I think maybe the question it says sentencing decisions to get training in regards to BAME children. I think it might mean remand decisions. Is what is being done to reduce or to stop these prejudices?
Yeah,
I think that must be what it means. Sorry, I've
yeah. So again, our research didn't really look at what that would actually mean, and I think it's a really fascinating question, to be honest. And so, how do you actually? I mean, in essence, I think the question is saying, how do you actually eliminate non-objective factor disproportionality? And you know, yes, I think I was at a conference last year that spoke about perhaps some of the usual techniques of unconscious bias.
We're losing you again, Richard. We might have to come back to you on that one if we can't. Yeah, I think we'll come back to you, Richard, on that, unfortunately.
I can come in on that one.
Thank you, Ikea. Thank you.
What I would say from practitioners that we need to be open about saying these things in court. Oh, Richard's still speaking.
A lot about actually what does actually work now. You know, is that any better? Yeah.
Yes, it is better. Yeah. No. Ikea, maybe you can go in now.
So yeah, I would just say that we have a number of tools now that allow us to say these sorts of things out loud. We can remind courts that they are more likely to make decisions that discriminate against Black children. We can refer to the Lama Review, we can refer to research, we can refer to the HM Inspector's report recently around the experiences of Black and mixed race boys in their supervision by youth offending teams. I think there is a lot out there that you can refer to that makes it undeniable without offending magistrates because they think you're suggesting that they're racist. I think we can quite quietly refer to these things, and also the anti-racist lawyer guides.
Yes, I don't know if you want to mention that, Ikea, the upcoming guides.
Yeah, well, I was involved in a more generic guide that was part of the Howard League, but we are in the process of, we're about to launch a child-specific guide, which has been funded by the Barrow Cadbury Trust. We have an eminent list of professionals and experts that have assisted us in the formulation of that guide, and also a significant proportion was informed by young people through focus groups. So that is about to be launched through YGLC very soon.
Yes, and I was going to mention it at the end, but I'll mention it now, and there's going to be a number of trainings as well. So we're going to be providing more information about that next week, so look out for that. So another question, and another question from the audience for Sean or Ikea. We struggle sometimes to argue, so I think we'll go with Sean first. So it struggles sometimes to argue down from ISS when it is suitable but not necessary. The risk of remand often encourages us to go for it in application to meet CPS objections and reduce the risk of a bail application that may result in a remand. Do you find that to be a problem, Sean, sometimes?
Sorry, can you repeat that?
Oh, sorry. Do you want me to repeat that
Please,
again? Yeah, so someone has said we struggle sometimes. I presume it's somebody from the Youth Justice Service, YOT. We struggle sometimes to argue down from ISS when it is suitable but not necessary. The risk of remand often encourages us to go for it in application to meet CPS objections and reduce the risk of a bail application that may result in a remand. So effectively, they're sort of feeling they should do an ISS where it may need that it didn't need to be so onerous as an ISS.
Yeah. I think the way around that sometimes is, I mean, what are the CPS objections, for one, make sure what they are. But you can put forward a bail package which is a robust bail package. It doesn't necessarily need to be under the term ISS. And if you put sufficient conditions in place which would address the concerns which the CPS have raised, then that could potentially be sufficient. ISS, I mean, it depends on what's available in any local area. Provisions vary between where in the country you are and what is available. But as an alternative, I think what has happened in the past is where you say, yes, we would potentially consider this ISS, but then the young person shouldn't be considered unsuitable for bail. Bail shouldn't be granted if a particular provision is unavailable in an area. So you have to be quite creative in saying, okay, maybe we would propose ISS if this provision was available in this area. It isn't. However, here is the alternative we've put forward.
Thank you. Do you have any thoughts on ISS, Ikea?
Well, in my experience, a lot of the time it's not available because there just aren't the resources. So that, you know, I have the issue the other way in that Youth Offending Teams are saying that they don't actually have, they can't fill 25 hours unless a young person's in education. So I feel that that's more of an issue, but I would certainly want to avoid, I would certainly want the starting point to be a bail package, no matter how full that looks, rather than on paper ISS, because then at least you've got somewhere to go if the bail package isn't working.
Thank you. Okay, next question for Richard, and just hoping that we can hear you, Richard. You mentioned swift justice being a problem. The biggest problem I have found is the lack of time before a case is called on. Overnight custody cases. I agree full consultation with relevant parties is crucial, but sometimes one is up against a dire desire of court to get on, with the case. So he's feeling rushed to get the case called on when things are not prepared, essentially. And you mentioning swift justice being a problem. Any thoughts on that?
I mean, our research certainly did pick out the issue of time and the pressure of time. And as I said, I think in the presentation, you know, the pressures of backlogs and so forth actually intensifies that issue. I think there is something there, though, to sort of again try and you know, I'm not a practitioner, so I don't know the necessarily the challenges, but to actually really try and ensure that at that first hearing, the magistrate or the judge is actually in full awareness of as much information as is possible, including any potential package as well. And I mean, this isn't actually on the same point, but I think it's another statistic that I think is actually quite, it's a similar point, but it's not the same, which is actually the number of children who have actually been held on remand for longer than 274 nights, which is a hell of a long time, increased by 10 percentage points last year. And again, I think that's due to the backlog, but that's not the point around the urgency of making a decision within court, but it's quite a salutary sort of number that it sort of actually sort of highlights how children can get effectively lost. I don't know if that's too strong a word, but sort of lost in the system, so to speak.
Thank you, Richard. Ikea, I don't know if you had any, how you get round, if you had any thoughts on you get round when you must have that a lot in court where there's sort of you're being pushed to be called on when things are not ready. I don't know if you have any sort of tips on that.
Yeah, I just think you just have to be robust in saying that you're not ready. There's good reason why you're not ready, and that the young person deserves to have that opportunity. You're happy to go on and address the court, address the judge, but you have to give time. Yeah. Thank you.
So a sort of general question really from someone at Surrey Youth Justice Service. Do you all agree that using words like offender rather than child and young person rather than child makes a difference. In Surrey courts, we only use the term child, and they believe it makes a significant difference in how they view the person before them, especially in relation to obtaining bail in serious cases. So I don't know if that's your sole experience, Sean, perhaps if you wanted to step in there first.
100% agree, yeah. You know, I think it's within court and external to the court, in terms of youth justice, the way we speak, the way we have professional conversations around young people, what language we use in everyday talk, language we use in courts, what language we use in Asset Plus, it's across the board. And I think where if we are using that term offender, but I think, well, why? Youth offending teams, that's why a lot of, we're now called Youth Justice Service. We don't just look at the young person as somebody who's committed an offence and an offender. We are more than that. They are more than that. They are a human. There's a lot more to them. So yeah, I think that I know a lot of guides have recently been published by NSPCC or other organisation around the use of language. But yeah, that's more recent. But yeah, totally agree with comment was, yeah, young person shouldn't be offender.
Thank you, Sean.
If I just came in there, Laura, just for a moment.
Yes,
I mean,
absolutely.
just from a youth justice board perspective, yeah, from a youth justice board perspective, we are using well, child first is our guiding principle, and I think, as Sean's just said, language is a hugely, really, really important aspect, and that's one of the reasons why in our future research we are going to be looking at the bail package reports themselves, because I think Ikea made the point around magistrates and potentially how they may sort of be inadvertently sort of discriminate against ethnic minority children, but I think well. So I think that's really, really important. But I would also go a little bit further than that and just throw it out there to say, what can we actually do to make courts more child friendly, both in terms of the sort of power differentials in just the space, I guess is the way that I might put that, and also potentially in actually allowing. We've done some systems mapping work recently, and people have sort of spoken about how children may exhibit what may be considered to be inappropriate body language and that sort of stuff, and actually having some sort of I don't know if it's a passport, so to speak, that can actually be communicated to the magistrates to say, you know, this child may laugh inappropriately or whatever it may be, and so they're kind of aware that that's actually an exit. You know, that's them exhibiting stress or tension in a particularly stressful environment. So I just think it goes a lot more than just thinking about how we should really use and operationalize that sort of child first narrative.
Thank you. That was really helpful, Richard. And I'm sorry, lost you a little bit at the end, but I think we all got most of what you were saying there. Is there anyone else that wants to come in on that about language, around language? I'll move on to the next question then. So again, for Sean and Ikea, how does a lawyer challenge a placement if they think a remanded child is vulnerable and yet they're placed in a YOI rather than a secure children's home or secure training centre? Sean?
Should I go first? Yeah, so usually it will come from the youth offending team, youth justice service, because the youth custody service are the ones who make a decision as to where a young person is placed, whether that be the YY, whether that be a youth offending institution, a secure training centre, or a secure children's home, and that depends on a number of factors, including their age, level of maturity. But they would be provided with a full assessment, which would have been completed by the OT at the time. If the defending team are advocating for a secure training centre, for example, and the youth custody service placements team say, no, we're placing this young person into a YOI, then we can appeal that decision. We can go directly to youth custody service placements team and give our rationale as to why we strongly advocate as to why a young person should be placed into a secure training centre as opposed to a YOI. There's a greater number of staff to young person ratios, etc., availability, and so on. So that is how we do that. In terms of the lawyer, I don't know if there's a separate kind of mechanism in terms of how they will go about that. But I'm not okay.
No, definitely my first port of call would be Yacht, because I'm well aware that it's their assessment that plays a large part in that. Yeah, that would be my first port of call, and then I mean, potentially you could challenge the local authority on that assessment, but you then have to have quite strong evidence to counter it, and it would definitely be much more. It would be much better to collate. If you thought there was further evidence that the youth offending team weren't aware of, then you could use that to persuade them to review their assessment, and then you could essentially both be on the same side in terms of challenging the Youth Justice Board as to the placement decision.
Thank you both, thank you. So next question again for you, Sean. Can you explain what delays might take place if a bail application is to be made for a child who is on remand at court but is not from the local area? So is it harder to get information quickly? I think Richard mentioned the courts push for swift justice. So is that something that causes real difficulties?
Yeah, good question. I guess it's variable, in short. I think it kind of links in with what another attendee has asked around how quick is it to get a bail package together. Like I said, I think essentially if we already know a young person scheduled to appear on the court list, we would have already made those preparations, liaise with the home defending team, which is the area in which the young person is ordinarily resident. But if it is a young person who's appeared directly from police custody in the court cells, then essentially I think we have to work together as a collective a lot more. So we would essentially be dealing with those cases as a priority, because we know generally there's less information known about them, where they're exactly from, what the circumstances are. So we would be making those calls to the local youth offending team, to the social care team, and yet it just depends on who answers the phone essentially, and if they're allocated workers available, what information can be shared and how quickly it is. We just have to reiterate it is urgent, they're a young person, they need to be taken into account, and they court awaiting essentially. As I says, we can just say to the court, we are not ready, we need more time here to get the information we need in order to advocate for the young person the best we can. So yeah, that was.
And I would just add to that really if because the youth offending team are dealing with all of the matters that are in court that day that are involving children, and they're normally no more than 2, maybe 3 maximum, depending on the number of courts. And if they have a trial in a court, then you'll have one person sort of tied up for most of the day. So I think basically we need to do it ourselves. If the youth offending team based at court, if it's not their case and it's not a local case and they've not had that liaison or had the chance to, then you need to be prepared to ring that youth offending team yourself and get the ball rolling.
Thank you. Next question. So this question is for Richard. Given the conclusions you mentioned from the University of Amsterdam research, that more time should be given to assessments at first remand hearings to prevent unnecessary remands, can we ask how the YJB suggests to overcome this? Does that make sense, Richard? I'm just.
Yes, it does make sense.
Thank you.
The honest answer is I work, probably going to pass the box slightly, but I work in the research and sort of data area. So my intuitive response to that would be, yes, we should be providing that as guidance to say we should be providing the time that is required and allocated for any particular child. I think somebody put in the comments, and I think it's Nazir, who put justice needs to be done and needs to be seen to be done. And the practitioner can object to being pressurised to act swiftly. So should they require more time due to being a vulnerable person, they should be allocated that. And I think Ikea also made that same point. And yeah, I would just reinforce that really.
Thank you, Richard. Thank you for that. I think we've got time for a couple more questions. And so I've got another one here for Ikea and Sean. If the test at the police station for remand is not met, why are the police keeping children in custody in the first place, and how can practitioners challenge this?
Oh God, don't even get me
sorry about that.
we had a whole seminar on Section 38 and the way that it isn't applied.
Is there anything that could be said in court about that when it gets to court?
Yeah, I mean, often when you've got an improper overnight detention, often the CPS are completely on board with it having not met the test. But obviously we know that children who come to court in custody are more likely to be remanded because they're essentially already considered to be in custody. So I would say really the best thing to do is to point out that potentially they were unlawfully detained overnight to the CPS in the first place, and potentially often what can happen is the prosecutor essentially just recites the remand application that was made by the police officer. Obviously not all prosecutors do this, but some do. They've got massive lists, they're dealing with 40 cases, they're literally just reading the objections to bail. Firstly, get the prosecutor to apply their mind to the law, as to whether the decision to detain them in the first place was lawful and whether they will actually meet the test for remand before you're in the position where they're just simply reciting the reasons.
Thank you, that's really helpful. So just a sort of technical one for you, Sean, is could you explain when there might be a difference between home local authority and a host local authority and what that might mean?
Yes. So, for example, there's a young person on the court list scheduled to appear. Their address is in Borough of Wandsworth, for example. However, once you make it to Wandsworth, we find out, oh, they're not really our young person, in the sense that they are a full looked after child and they have been placed in Wandsworth by Borough of Greenwich, for example. So Greenwich would have overall responsibility. They will be the court designated local authority with responsibility for that young person. So they would be the home yacht if essentially the young person is going to Greenwich, and then Wandsworth, they will be the host yacht, because they, in practice, if the young person's on bail subject to an order court, then Wandsworth would generally be delivering the day-to-day work with the young person as the host yacht, but Greenwich would maintain overall responsibility for the case in terms of any breach or compliance issues and completing any pre-sentence reports, for example.
Really helpful, thank you, Sean. Okay, back to you, Ikea. Is credit for time on curfew definitely given to youth receiving a custodial sentence? And if so, what is the statutory basis for that credit, and how does it get applied given the minimum 4-month DTO?
Well, that is the problem with DTOs, is that there is no automatic deduction that's sort of.
Oh, you've gone on mute, Ikea.
So you have to raise with the court specifically. You'd have to do the calculation yourself and explain what the equivalent period of remand that they would be, considered to have served through that curfew. But in relation to a DTO, it's not. They have to take it into consideration.
Thank you. I'm just looking at a couple more questions. Okay, so a question for Amos. If the court refuses to give you more time before you're being called on, do you have suggestions of where this can be escalated to?
If well, it's unusual. I mean, certainly from a Crown Court point of view, the judge should normally give you sufficient time, and if you don't feel you have enough time, then you can obviously make the application to the judge and ultimately adjourn it. If you don't, I don't think you should be rushed into a situation where you're having to. But yeah, I don't know if that assists. I mean, was it addressed?
Yeah,
to
that's
yeah.
Yeah, that's in the Crown Court. That's in the Crown Court. If there's any differences or anything that you could do to escalate it, that's great. Thank you. I'm just looking and whether there's another question here. For Sean or Richard, in the Youth Justice Service, do the police placed within the yacht complete bail address checks? And does this involve a home visit? And Richard, does the YJB have best practice on this?
Are we talking in the context of court bail addresses proposed on the day of court?
It's not clear from the question, but I suppose you can answer that in any way.
Yeah, usually, I think the practice is that the youth offending team in the area where the address lies, they'll be the ones who would ask to complete the address check, given that will be the area in which the young person is proposing to reside. Whether that is the yacht and the local yacht is there, potentially. There is the PLO, the police liaison officers who are based within courts. They can assist sometimes, depending on well, if they're there and they're able to. Otherwise, yeah, we can contact our own yacht and possibly get them to kind of pull some strings, so to speak, whether they can do an address check or liaise directly with the yacht police in the area where the address is to complete that address check. Yeah, in terms of physically doing the home visit, I think that just depends on resources and I guess the nature of the offence and the circumstances surrounding the case. But yeah, it should certainly be best practice to do so.
Okay, that's really helpful. Thank you. Just one last question for Shauneen and Ika is, somebody has said, I've come across legal reps who have refused to apply for bail applications despite Youth Justice Service stating the child is entitled to bail. What can a child or family member do in this situation?
I would say that obviously the role of the solicitor is there to advise, but they have to take instructions from their clients. So I think that would be a significant breach of trust and confidence if you refuse to make a bail application when your client is saying that they would like to, and you have the support of the youth offending team. That would be completely alien to me. And I think that obviously sometimes you know full well that an application might be completely hopeless. However, that's our job, is to stand up and make the client feel like what they've asked you to do is being done, and that you've given it a shot and that's your best shot. And then it's a matter for the court to refuse it. So if that happens, then obviously the family may consider that such a significant breach of trust and confidence that they would consider transferring to a different legal representative, and they may wish to transfer on that basis. Obviously, you know, bail is a massive issue, and I've you know, had clients who even, you know, you've made the application, it was hopeless, it's been refused, and they're complaining, and that they held you responsible for that. But I think that's just, unfortunately, that's our cross to bear.
Thanks. Thank you, Ika. Sean, is there anything you wanted to say on in relation to that, or I could cover it?
No, nothing. I think I could cover everything really. Yeah.
Okay, so I think we've come to the end. So I just want to thank all the speakers very, very much for coming and giving their time on this. And I hope you all enjoyed it and that you used the guide. The guide's on the website. You should have a copy of it. And we've also always got our advice line for any inquiries at all. And as Ika mentioned, we will be launching a guide on that we have done in collaboration with children and young people on fighting for racial injustice in the criminal justice system, and that's going to be launched with a number of trainings. More information about that next week. But otherwise, thanks again for coming, and that's it. Thank you all.